Hello and good morning, everyone, and welcome to FSRA's Financial Protection Framework webinar. It's an inaugural webinar that we're pleased to be able to have you all attend today. My name is Glenn Pedasri. I am the Executive Vice President of Policy as well as the Chief Consumer Officer at FSRA. My preferred pronouns are he, him, and I have the pleasure of being your MC today. Before we begin today's session, I'd like to remind everyone of a few rules of engagement. As you'll note as an attendee, you have been automatically muted and your video has turned off. We will have a Q&A session, and once we approach the Q&A segment, you will be able to direct your questions to us via the moderated Q&A icon on the top right-hand side of your screen. To submit your question, please type it in the box, and if you would like to remain anonymous, you can check off the anonymous box before hitting submit. Once I receive your questions, I will be reading them on the line and redirecting to our speakers for a response. Please also note that this webinar will be recorded, and the recording along with the transcript, presentation deck, and any unanswered questions from the Q&A period will be available post-event on the FSRA website. Now that we have that out of the way, and as most of you already know, FSRA held the first consultation on the Title Protection Framework between August and November in 2020, and we received over 43 written submissions. In addition to the formal consultation, since 2019, we have been working both formally and informally with a variety of stakeholders to help inform the design of the Title Protection Framework. We've met with industry stakeholders, consumer groups, including our Consumer Advisory Panel, to discuss in detail the benefits and impacts of title protection to businesses and associations, title users, and consumers. On May 11th, FSRA reposted the proposed rule and application guidance for a second consultation, which is intended to close on June the 21st. We also proposed new supervision guidance, which outlines FSRA's approach to monitoring and enforcement. To help you understand the updates to the proposed framework today, we will be providing information on our rationale and key principles for design of the framework, key themes that we heard during the consultation, and findings from our consumer research survey, the proposed changes to the rule and application guidance, the proposed supervision guidance, and our approach to establishing a fee structure, as well as next steps for implementation of the framework. We hope that you will find today's webinar informative. And just before I hand it over, I wanted to just introduce who are the guest speakers with me joined from FSRA today. So as you will see on the screen from left to right, Mark White is our CEO, and he'll be providing some opening remarks in a moment, followed by me, and I'm your MC today. Houston Loke is going to be one of the presenters today. He is the Executive Vice President of Market Conduct. And Joel Gorlick will be the other co-presenter. He is the Director of Policy of Market Conduct supporting Houston's area and has been the team with the team supporting the development of the Title Protection Framework. Joined with Joel and Houston are Tim Mifflin, who is our Senior Manager in Policy leading the FPFA framework, as well as Andrea Foy, our Senior Policy and Technical Lead, who has been instrumental in the design of the framework itself. So with that, I am pleased to provide the microphone over to Mark White, our CEO. Over to you, Mark. Thank you.
Thank you, Glenn, and good morning, everyone. Thank you for joining us today for FSRA's technical briefing on our proposed Financial Professionals Title Protection Framework. An important part of FSRA's mandate is consumer protection, and we see our proposed framework as an opportunity to protect the public through working with stakeholders to implement minimum standards in Ontario to govern the use of the financial planner and financial advisor titles. Proactive stakeholder engagement is hopefully a FSRA hallmark, and your input is essential to successfully finalizing and implementing this. Today, as Glenn mentioned, we're excited to walk you through the updates we've made to respond to the feedback we have received to date and to describe some other key building blocks of the proposed framework. We welcome your questions on the framework. Today is an opportunity to hear from you about this important consumer protection initiative. FSRA's proposed title protection framework will give definition to the financial planner and financial advisor titles for their use in Ontario, and will do this by establishing minimum standards for their use. The framework aims to ensure that individuals using these titles are appropriately qualified to serve their clients and well supervised if issues arise. This will promote professionalism and proficiency and it will help remove consumer confusion and will enhance consumer confidence. Importantly, the proposed title protection framework will not result in a new regulatory regime for individual title users. Instead, FSRA will leverage existing regimes for licensing and designating financial professionals. Reusing these existing regimes will minimize burden and cost and will avoid the duplication that could occur, and this should help ensure efficient and effective regulation. Once the framework's in place, financial planning and advising qualifications and activities in Ontario will continue to be overseen by the licensing and designation granting entities that FSRA has recognized as credentialing bodies. FSRA will protect consumers by overseeing approved credentialing bodies to ensure ongoing consistency with minimum standards. FSRA will also protect the public by ending title use by those who are not approved by an approved credentialing body. With that, I'll hand it over to Houston, but I look forward to hearing your comments and feedback during the Q&A session, and of course, to receiving your submissions to our public consultation. Thanks very much. Houston, over to you.
Thanks very much, Mark. So all of you in the audience, please accept our welcome in terms of continuing this discussion on the financial planner, financial advisor title protection framework. The agenda that is on screen sets out what we're trying to do today. We're going to talk about the rationale and key principles. We're going to talk about key themes from the consultation, and then we will proceed to go through what has changed and what is new, what are next steps. There will then be a time for Q&A, and we really wish to hear from you. So please get your questions ready as we go through this discussion. And then we've got contact details and additional items in the appendix that will give more background on some of the material that we'll be discussing over the next little while. So let's go right into things, and let's talk about the rationale and key principles. As of right now, there are no rules in terms of the use of titles, and in particular, when we look at the landscape and consider the needs of retail investors, it is currently the situation that an individual with limited proficiency can hold themselves out to be a financial advisor or a financial planner without any level of assurance or oversight. So the title protection legislation that's been passed in Ontario represents the fulfillment of a promise that certain titles, financial advisor and financial planner, are only to be used by individuals with a certain level of proficiency and accountability. So let's go through these key principles. The first one, Mark mentioned increasing consumer confidence. We wish to establish minimum standards so that when an investor meets with their advisor or gets introduced to their planner, they can be confident knowing that there is a certain level of proficiency and accountability. Only qualified individuals will be permitted to use those titles. I'll just note here that the legislation speaks to the concept of being applicable to an individual. So this doesn't apply in terms of businesses that, for example, act as financial advisors for a large, complex corporate transaction. That's not the scope of the legislation. That's not the intent. What we are doing is requiring individuals using the financial planner or financial advisor title to meet conduct requirements and professional standards. Over on the right-hand side of the page, at the same time, as we increase consumer confidence through title regulation, we want to support regulatory effectiveness and efficiency. So we want to work with existing licensing and professional designation bodies to become approved credentialing bodies. We want to leverage what they have to offer and the infrastructure that they already have in place. This will grant individuals with existing licenses or designations the right to use these titles. Conduct in terms of their business activities will be overseen by the approved credentialing bodies, and FSRA will oversee the credentialing body as the grantor of the title. And we've been in discussions with some of our partners across the country to provide a national model for adoption in other Canadian jurisdictions, and so those discussions are underway. In terms of a quick overview of the title protection framework, it's important to note the separation of duties. What is FSRA doing and what are credentialing bodies doing? Well, on the left-hand side of the slide, we expect to work with credentialing bodies as they apply. There will be transition issues. We're going to implement consumer protection standards as the framework evolves, and we will have a surveillance and enforcement function, including the ability to revoke credentialing body approval and issue compliance orders. Also under consideration is the development of a consolidated public registry that will make it much easier for a retail investor to determine who it is they're working for and what gives that individual the right to use a particular title. We think that's an important piece because it really fills a void that currently exists. Again, currently as things sit, there is no regulation on and no restriction on an individual to use the titles financial advisor and financial planner, and there is no accountability. So let's switch over to the right-hand side. Credentialing bodies will be granting credentials. They will be required to maintain continuing education standards. They'll be monitoring conduct, and that's an important piece. Why? Because strong conduct standards are important, but we do not want to duplicate the efforts of credentialing bodies. So we will oversee the credentialing body, but the credentialing body will review and oversee the conduct of its members. And of course, the consequence of that, if there is found to be a case of misconduct, they will be able to enact disciplinary measures. Let's go on to talk about what the themes were in our consultation so far. So these 7 boxes set out what we've heard. And just as a quick reminder, after we go through this, then we're going to switch things over, and then Joel will talk about what's changed. So looking at these 7 boxes, here are the concerns that we heard, and I want to just very quickly go over some of the thoughts that we have. First of all, one concern was that the framework could introduce additional burden and duplicative oversight. And what I'd say here is that the primary objective was really to create that minimum standard for title usage. We want to leverage existing frameworks for licensing and designation of financial professionals, and we've been working with entities that do this and bodies that do this in the hopes that we can leverage their efforts and that they would consider working with us as credentialing bodies. This will allow individuals to continue to conduct business as seamlessly as possible using these titles without additional burden or disruption. Next up, we did hear that there were some concerns in terms of exemptions. Currently, the FSRA rule does not contemplate exemptions, and we believe that if there are exemptions, that could dilute the purpose of the rule, which is to provide confidence and to provide a minimum level of proficiency and conduct oversight. We also heard that the FSRA powers to enforce the framework may not be sufficient. So this is the middle box here. So the parameters are set out in the title protection rule. Our enforcement tools will include the ability to revoke a credentialing body or issue a compliance order. The credentialing body will retain the conduct oversight of its own members. What else did we hear? We heard that FSRA should consider a harmonized approach with other jurisdictions, and we wholeheartedly agree with that, and we have had discussions with some of those jurisdictions. And along the bottom, we heard that the transition periods might be too long, that we should develop and implement a public registry, and we had questions about fees. So here's what we have to say about that. As part of our public consultation, we've proposed changes to the transition periods. We're also considering implementing a public registry of FA and FP credential holders to be made available at the FSRA website. And we have issued a publication that speaks to the FSRA fee structure, and that was released on May 11, just a few weeks ago. So that brings us to the conclusion in terms of the key themes. I'd like to now pass the time over to Joel, who will take us through the next part of the presentation. Joel?
Great, thank you so much, Houston. Now that Mark and Houston have given you some of the background on how we got to this stage, I will give you a quick summary of what's in the materials we currently have out for consultation. And first, as Houston mentioned, we can talk about what's changed from the materials that we released for consultation last year. So Houston just told you about some of the common themes we heard in the feedback we received last year. And as he mentioned, we are proposing 2 amendments in response to some of that feedback. Maybe we can just move to the next slide. One of those things, as Houston said, is we are shortening the transition periods that were previously proposed. Previously, it was a 5-year transition period for financial planners. It was 3 years for financial advisors. We are proposing to now shorten those to 4 years and 2 years, respectively. We heard almost universally from stakeholders that the proposed transition periods were too long. We're shortening the period of time that individuals can continue to use the title without an approved credential. But these 2-year and 4-year transition periods will still provide sufficient time for individuals to obtain a credential if they still need to. And then the other change, as Houston mentioned, was, as at the bottom of this slide, we added a requirement for credentialing bodies to provide FSRA with the data that we will need to maintain a public registry of financial planner and financial advisor credential holders. This will help ensure that consumers have a way to check that their financial services provider holds an approved credential that actually permits them to use the financial planner and financial advisor title. So on to the next slide. To talk a little bit about the application guidance. We put this out as part of the package last year. Based on feedback we received, this is the guidance that sets out our approach to administering applications from credentialing bodies. Based on some of the feedback we received last year, we are proposing some changes. For your reference, part of the package we've posted for consultation actually includes a short 2-page summary of all the changes we've made to this guidance, because we made a lot of them. But I'll quickly highlight just a few for you that are listed on this slide. One is we added a proposed minimum standard for a credentialing body's education and curriculum content. That's intended to provide credentialing bodies with some additional guidance on what FSRA will be looking for in order to obtain approval of a credential. We were told that a little bit of clarity was needed there. We also amended the technical knowledge standard for the financial advisor title specifically, so that would include at a minimum knowledge of investment products. We lengthened the period of time that FSRA has to review an application. It was originally 30 days, and we've now extended that to 60 days. And we've also made changes to the processes and procedures that credentialing bodies will be required to demonstrate. So that includes they need to have a process to assess the suitability of their credential holders, a process to share information with regulators and with other credentialing bodies, for example, in the event that enforcement action is taken against a credential holder, and finally, processes for identifying, managing, and addressing conflicts of interest. So that's a quick summary of what's changed from what we released last year. And now if we move down to the next slide, I can give you a quick summary of what's new in this package that we did not release last year. So one thing that's new is a piece of guidance that we're calling the Supervision Guidance. This sets out FSRA's approach to supervision under the title protection framework. So this new proposed Supervision Guidance provides an overview of a few different things as listed here. One is how FSRA intends to monitor and supervise credentialing bodies, as well as our complaint handling protocol, how we would take action against individuals who use the financial planner or financial advisor titles without having an approved credential. That is something that is provided for in the legislation. Our approach to assessing titles that could reasonably be confused with the financial planner or financial advisor titles, also provided in the legislation. And finally, how we will enforce breaches of the Financial Professionals Title Protection Act. So on to the next slide, you'll see the supervision guidance, if you look at it, actually includes some illustrative examples of titles that FSRA considers could reasonably be confused with the financial planner and financial advisor titles, as well as titles that in our view are not likely to be confused with the financial planner and financial advisor titles. It's by no means an exhaustive list, but I would certainly encourage you to have a look at it. I know many of you will have comments on some of the examples that we have chosen, and we certainly welcome any thoughts or comments you may have on any of them. Our overall approach here will be to review any concerns or complaints that are brought forward about the use of titles that could reasonably be confused with either the financial planner or financial advisor title on a case-by-case basis. So what you see here at the bottom are a few examples that we've taken a few examples from the larger list that we've included in the supervision guidance, which again, I would encourage you to have a look at. Very quickly, I'll go over the examples that we've used here. So really, some of the most obvious examples, any variation in spelling, abbreviation, or the language used for the financial planner or financial advisor titles. So if somebody uses the FP or FA abbreviations, calls themselves a financial advisor with an E instead of an O, those we consider would certainly be reasonably confused with the financial planner and advisor titles. The next one down on the left-hand side, if you use a title that has any combination of the words financial planner or financial advisor, but with other words included, for instance, we've used examples like financial wealth planner, financial planning advisor, combinations of words like that we consider would be reasonably confused with the FP and FA titles. And finally, another example would be if you use it in combination with another term like senior financial advisor, financial advising coach, that type of thing. On the right-hand side, and I know there will be certainly thoughts about a lot of these that are on the larger list, examples of titles that we think would likely not be reasonably confused with financial planner and advisor. So for instance, the word just advisor on its own with an E or with an O, we don't necessarily consider would be reasonably confused with with financial advisor necessarily. All this again will be considered case by case as they're brought to us. Wealth advisor, wealth planner, those are other examples, as well as senior advisor or advising coach. Those are examples we've chosen. We sort of cherry picked from that list that we have out there as part of the supervision guidance. So I'm sure that many will have comments and thoughts on that, and we definitely love to hear your feedback. So moving on to the next slide, the last new element I want to highlight for you in this package is the proposed fee structure for the framework and the types of fees that would be charged to credentialing bodies under the framework. So overall, our proposed fee structure for this title protection framework is designed to support FSRA's operations as an independent, self-funded regulator. As we're noting here on this slide, in our publicly released business planning materials that are out there, FSRA has estimated costs for this framework. A little further down the slide, you'll see $3.1 million to design and implement the framework up to March 31st, 2022. We're calling those the startup costs, as well as approximately $1.1 million in annual regulatory costs to oversee the sector once we launch. So as we're noting here under the fees, we are proposing to charge credentialing bodies an application fee of $10,000. That's a flat fee for approval of a credentialing body, plus a fee of $5,000 for each application for approval of a financial planner or financial advisor credential. There may be examples where one credentialing body may want to apply, but may want to apply for more than one credential. So that covers that scenario there. In addition, we are also proposing to charge an annual assessment, and that consists of a few different pieces, as you'll see here. One is a fixed annual fee, and that amount is $25,000 to cover a portion of FSRA's operational costs to oversee the sector, as well as a variable annual assessment, and that will be based on a credentialing body's proportion of credential holders, so how many credential holders they have. And for the first 5 years of the framework, an additional annual fee that will enable recovery of our startup costs. So startup costs will be amortized over 5 years. And again, those will be allocated based on each credentialing body's proportion of credential holders. Now, overall, as noted here, we've estimated that the proposed structure would result in an average annual cost of approximately $22 per credential holder. And that average cost should actually decrease once the startup costs are fully recovered. Could go down to about $14 per credential holder based on what we're estimating right now. All of this is laid out in the appendix that's included in the consultation package. So you'll see in the consultation materials as well that we've included some illustrative examples of what these fees could look like for different sized credentialing bodies based on this proposed model. So I would encourage you to have a look at that. And I should also note that we do plan to launch a public consultation on a separate FSRA rule regarding fees under this framework this summer, hopefully, after the conclusion of the current consultation that's ongoing right now. So that was a lot of information, I realize. I'll talk very quickly about next steps before I hand things back to Glenn for the Q&A. We are exactly halfway through our current consultation period. The consultation period will end on June 21st. We're going to consider all the feedback we receive, including what we hear from you today, to determine if additional changes to the proposed rule and the guidance that I just talked about may be needed. If you haven't already checked it out, the link to the consultation is included right here on this slide. I'm sure folks have seen this, but definitely encourage you to go and look at that. As I mentioned, after this consultation is complete, we do plan to launch a 90-day consultation this summer on a proposed rule regarding fees under the framework. After that's been completed, the plan will be to finalize the rules, submit them to the Minister of Finance for approval, which is part of our process. And then, as noted here on this slide, we will also work with credentialing bodies after that time to make sure that the application process runs smoothly and that our supervision framework is up and running when we implement the framework. Subject to all the approvals I just mentioned, we're hoping to be able to launch the framework in the first half of 2022. So I know that was a lot of information. I appreciate your patience. Now we'll get to the most important part of this event, which is your questions. I'll hand it back to Glenn to take us into the Q&A.
Thanks, Joel. Thanks, Joel. I just want to make sure can you hear me okay? So just thank you very much, Joel. We're going to be moving into the Q&A portion of the event. So in fact, we've actually been receiving a number of questions and answers throughout the presentation. So let me just start off by reminding folks that, because it was a question that came through multiple times, we will be actually posting this presentation up on the FSRA website for people to be able to download on their own and provide their own questions as a result of that, as well as a reference document. There are several questions already posted. I'm going to do them in order as I see them. In some cases, I may paraphrase if there were multiple questions around the same topic, but rest assured, we plan to post our responses up on the FSRA website as well, and any questions that did not get answered will also be posted on the FSRA website with a response. So with the first question, it's coming in as, will advisors already actively certified as CFPs or PFPs, Certified Financial Planners, or personal financial planners be grandfathered under the rules? Or will it be a two-step process where the firm and the individual must be registered? So over to either Houston or Joel to respond.
I mean, Houston, I can jump in on this one if you want. I would say, first of all, there isn't any grandfathering. Hopefully people can hear me. There isn't any grandfathering under the framework. There are no exemptions either for existing credentials. I think, as Mark said off the top, we're looking to leverage existing credentials that are out there in the marketplace right now. Certainly the CFP and the PFP are examples of financial planner credentials that exist out there right now and are given out by existing bodies. So definitely we've been in conversations with those bodies about what that could look like if they were to come into the framework as credentialing bodies and apply for that. I guess what I will say is there is, as we mentioned earlier, a transition period built in where in the case of a financial planner, because we're talking about CFP and PFP, there will be a 4-year transition period after the framework is implemented. So if somebody does not have a credential that is considered to be an approved financial planner credential, they will have 4 years in which to go and arrange to get one. So on day one, when the framework comes in, just not having that credential right away won't mean, if you've been calling yourself a financial planner for however many years, 10 years, let's say, you'll still be able to do that, but only on a time limited basis for the first few years that the framework is in place. Hopefully that helps.
Thanks, Joel. So thanks, Joel. I hope the microphone switched back to me. Thanks, Joel. So I'm moving on to the second question. And what is FSRA's rationale for determining the LLQP is not sufficient for the FA title use? Houston, do you want to take that?
Sure, I'll take that one, Glenn. So the LLQP is very heavy on the product side, and we believe that there are a lot of benefits from the LLQP, and it of course provides the proficiency standard for life agents. But we don't believe that it matches up sufficiently with the standard that we're trying to achieve in terms of the full package that a financial advisor is intended to deliver. We may consider whether there are alternatives by which a life licensed individual can bridge the gap to meet the standard for financial advisor title usage. There may be credentialing bodies that can step into the discussion to bridge that. And we will continue to engage with industry on the LLQP content as we finalize our position.
Thanks, Houston. And I'm moving to the next question, and it is around, will FSRA retain ultimate jurisdiction over the conduct of individuals' FPFAs? For example, what happens if the credentialing body does not take appropriate action to protect consumers? Could FSRA intervene directly? I'm going to throw this one to you, Houston.
Yeah, so this speaks to the heart of what we're trying to accomplish here, to the extent that there is that there are concerns in terms of conduct that are we want those to be handled by the credentialing bodies. That's the basis that their application would be submitted to us. They would say, we have conduct standards, we have proficiency standards. Here is our enforcement package. This is what we deliver in terms of investor protection. On that basis, FSRA, we are applying to be a credentialing body. FSRA would look at that, and we would be entitled to do reviews. And so what we can do, if we determine that in fact that promise is not being kept, and in fact they are not appropriately overseeing their members, then what FSRA could do would be place terms and conditions in terms of their credentialing body status, or if the conduct warrants such a move, we could revoke the credentialing body status for that credentialing body. And if that's the case, then the individuals that are part of that framework would not be entitled to use the title.
Thanks, Houston. I'm just moving to the next question. It was provided by Melissa. Good morning. Can you please speak to more about why the SROs, so IROC and MFDA, might be considered to be CBs, credentialing bodies, while the CSA would not? As far as I understand, IROC and MFDA do not provide courses credentials for individuals. Is the idea that SROs oversight of firms themselves is sufficient? If that's the case, why is the CSA not also included? With thanks for any additional context you can provide. So Joel, do you want to take that one?
Sure. I think the basic difference is in the SROs, MFDA and IROC already partner with an education provider right now for the purpose of establishing education standards for registrants. So really, in our view, they're well placed to act as a credentialing body. I mean, again, there are no credentialing bodies yet. The application process is being set up, but I would say that's the main difference. In addition to having direct oversight of the registrants, the SROs already basically are in the business of providing those education standards, which is a key component of what credentialing bodies will do. So that's essentially the reason why versus the CSA, which has oversight but does not have that function, as I understand it. I don't know whether Houston, you had anything to add to that.
Well, I just mentioned that it's also reflects one of the hallmarks of the that a credentialing body can subcontract for things like education. And so it doesn't mean that you have to have it all in-house. When we review a credentialing body's application, we're going to make sure that we think it can meet the minimum standards. And if it doesn't at inception, we'll be able to meet them in a short period of time. But I could do that indirectly through also having an education partner. So that doesn't mean that the education partner also has to be a credentialing body.
Thanks, Mark, for the follow-up. I'm actually going to use MC prerogative and combine a few questions. So the next question is, why is the scope of title restriction so narrow? What is the point of the exercise if someone could change to a title that from a consumer perspective is really quite similar? For example, how would a title like wealth consultant or advisor that appears to be outside of the scope materially improve customer confusion? In addition, can you also talk about why titles like president or vice president that were prominently addressed in the original versions of the FA title project also be excluded?
So I can take a crack at this one, Glenn, if that's okay. I mean, I would say the legislation as laid out, the Financial Professionals Title Protection Act, does speak to the two specific titles, financial planner and financial advisor. We're aware that previous initiatives have proposed to go further than that and actually include a wide variety of other titles that are in use in the marketplace. But as mentioned, the Financial Professionals Title Protection Act has a provision that says it's those two titles, financial planner and financial advisor, and those that are similar to or could be reasonably confused with those two titles. And we understand that that can be interpreted potentially in different ways, and that's one of the reasons we've put those titles for discussion in the guidance, as I mentioned earlier. I think what I would say is we're certainly open to the idea that there are ways that we can that we could look at different titles in different ways. I definitely would say on the financial advisor and financial planner side, both there are a number of different titles, like you said, president, vice president, that are in use in different corporations that are not considered to be in scope for this exercise. I think the idea is to give the financial planner and financial advisor titles specifically some cachet in the marketplace, so that there's value to people wanting to have those titles. Ultimately, I think hopefully once this framework has been up and running for some time, there will be a reason that people will want, as opposed to people saying, oh, I'll change my title so I can avoid this regime. It's more, I want to have that title because I want consumers and investors who come to me for my services to know that I have an approved credential and that actually means something in the marketplace, as opposed to right now when, as Houston said earlier, the two titles literally don't mean anything because anybody can use them right now. Hopefully that helps a bit.
Thanks, Joel. So I'm moving to the next question. Why does the transition period, especially for the FP credential, need to be so long? What is the harm in shortening it dramatically, say to 2 years? If you want to protect titles, I would think there is no time like the present in getting on with it. Joel, do you want to take this on transition periods?
Sorry, yes, looking for the unmute button. So I think the idea is what we heard during our consultations going back really the last year and a half, it takes some time to get some of these credentials, in particular on the financial professionals, on the financial planner side, since that's something that's mentioned here. Just to take the CFP as an example, we've been told it can take up to 3 years really to get that from start to finish. So really building in a 4-year transition period really just allows that 3 years plus a bit of a buffer to be able to get that credential. Other credentials may take a little bit less time. We've heard that on the financial advisor side, many credentials you can get within sort of the 12 to 18 month time frame, and that's why that one is a 2-year transition period instead of 4. So that's there. We had to sort of draw a line somewhere, I would say, and this is again in recognition. This transition period is for people who are already using the title, and we have set a date for that. You can't just sort of have started using it, yesterday and say that you are entitled to go through this transition period. I believe the date we've chosen is January 1st of 2020. So you have to have been using it for at least the last, right at this point, year and a half. By the time we implement, probably 2 years, to be able to have access to that transition period in the first place. Hopefully that helps.
Thanks, Joel. I'm going to move on, and again, there's several questions in around the registry. So can you speak a little bit to what might be included in the registry? And in particular, will the proposed registry include disciplinary actions for all Canadian financial services jurisdictions and regulators? Houston, do you want to take that?
I think that the use of a registry will allow investors, in particular retail investors, to take a look and determine how their advisor meets certain qualifications. So I think the content of the registry is still under development, and I think the suggestion here is an interesting one that we will take away and reflect on. But I think that the concept of having a registry where someone can check to see how their financial advisor or their financial planner is credentialed is one that we do want to bring forward, and that will be an easy way for investors to check on status of their profession.
Ben, if I can just quickly chime in, it's an interesting idea to do it through the registry, but one of the things that is in our current consultation, because we've heard this through our stakeholder engagement, is it's very important because we'll have multiple credentialing bodies, that there be good communication between those credentialing bodies and that there be consistent information. So, and we're also hoping that this can be a platform. We know Quebec already has an FP regime, but we're hoping that this could be something that could be adopted, particularly because the potential credentialing bodies are national. So we're actually hoping that over time that this would evolve to where our credentialing bodies, they will have positive obligations, and we'll develop mechanisms with them through their credentialing body approvals so that they will share that information, so that if someone is sanctioned, and hopefully this, as I say, can have the potential to be multi-jurisdictional and beyond Ontario across Canada, so we'd get that information from all credentialing bodies and hopefully across provincial boundaries as well. So it may not work through the public registry, but we believe that information sharing is very important because there needs to be consistency so that somebody doesn't just, get sanctioned and get their title use removed by one credentialing body and that they move to another credentialing body without us making conscious decisions as to why that would be okay.
Thanks, Mark. Houston, I'm going to give this question to you. It's really around the application process for a credentialing body, and the question is really around the 60-day application review clock. So can FSRA stop the 60-day application review clock if the applying credentialing body fails to provide adequate materials or responses to FSRA queries during the application process? Maybe you'll talk a little bit about the application process and then that specific question. That would be helpful.
Yes, so we have developed an application, process, and we have a team that is being developed that will look at these applications. The materials must be complete, and our service standards will rely on credentialing bodies submitting a full application. So to the extent that there is incomplete information, then the clock would essentially stop. If there are questions related to the specifics of the application, again, we're happy to take that offline. And there are materials that have been submitted for public comment that speak to that process. The process, the legislation sets out the content of that application in terms of things like governance and the proficiency standards that will apply, the oversight from a conduct perspective, and those who are reflected as part of the application.
Great, thank you, Houston. There are a few questions in here related to FSRA's enforcement powers, and so I'm going to try and do a combine here, but essentially, can you speak to what FSRA's enforcement against an individual will look like? And can you talk a little bit about the powers that we have? And in particular, can you speak to whether we have the ability to strip someone of their credential or their title use? And are there any fines for misconduct? Joel.
Yeah, so I can speak to that for sure. There is very limited ability under the legislation for FSRA to take action against individual title users. Really, that's limited to FSRA has the ability to issue a compliance order against an individual who uses a financial planner or a financial advisor title, but who does not have an approved credential. For those that do have approved credentials, as Houston went through earlier, it's really the credentialing bodies that will have responsibility for oversight of those individuals. So FSRA will not, for instance, have the ability to take away a financial planner or a financial advisor credential from an individual. FSRA has oversight of the credentialing bodies. And the credentialing bodies, if they see a conduct issue or some reason that that they feel that one of their credential holders needs to have action taken against them, that is up to the individual credentialing body to take that action. So really, our most of our enforcement is with respect to the credentialing bodies directly. There are some enforcement provisions in the legislation with respect to what action we are able to take. And then that's up to and including potentially revoking a credentialing body's approval if we find that a credentialing body has not lived up to its obligations under the Act. I don't know if Houston, you have anything to add to that.
No, that's great, Joel. Thank you. I'm going to go to the next question. The requirement for maintaining credentials for titles. So this is on the title user themselves with the credentialing body. Will this be a compliance department responsibility or a function of the credentialing body to oversee? Or is there an audit process to this from FSRA's side? And what might an audit look like? I'm going to give this one to Houston.
We anticipate that we would do risk-based reviews of credentialing bodies in terms of maintenance of their requirements for titles. So in their submissions to us, they would tell us about their continuing education standards and their oversight standards for their members. We expect that we would meet with them again on using a risk-based approach to determine if those obligations are being met. And if that's the case, then things would continue. We do expect that engagement with credentialing bodies and their level of supervision in terms of their own members and the results that they can share with us will go a long way in terms of doing two things. First of all, it's really ensuring that consumers can be confident when they engage with the services of a financial advisor, financial planner. And the second thing is leveraging off of their skills. Their compliance programs and the results that they share with us will determine the frequency and the intensity of our own reviews, because if they're doing a good job in terms of that oversight, then there will just be a better arrangement where we will need to engage with them less in terms of ensuring that's being done.
Mark, did you want to add to this?
Yeah, just, because these last couple of questions, I mean, there's a very important design choice that we take as a given because of the legislation. FSRA's role here is to make sure that the credentialing bodies are doing a good job, whether that's in the entry-level qualifications or the ongoing supervision of the people who are using the titles. And we are, of course, supervising those who are not approved, or we're monitoring those and sanctioning them if you're not part of a credentialing body, so you don't have the right to use the title. But leaving that aside, the design choice is that to keep the cost down and to have only one level of supervision for the individuals who are title users, that we're going to look to the licensing and the designation granting bodies who get approved as credentialing bodies to do that job rather than duplicating that. And then, that's a design choice, and I think it's a good one. So we're glad to receive comments on that, but we do take that as a given. And I don't think we'd be able to put this regime in place so quickly, and frankly, relatively inexpensively, as well as dealing with the multiplicity of existing, good licensing and designation bodies that exist, and have people out there who may be using the FA or FP title. I don't think we could put that in place in any way unless we did use that leveraging off of the existing credentialing bodies and not trying to duplicate that.
Thanks, Mark. So there's a question here, and I'm actually going to just paraphrase it based on the way the question was posed. But essentially, how does FSRA contemplate preventing a qualified title user, either a financial planner or a financial advisor, from offering the services that they're not entitled to offer? So for example, if a financial advisor starts offering financial planner services, but they only are qualified or have the permission to use the financial advisor title, and conversely, financial planner to financial advisor, how does the client know what they're getting? And how do you know, or how do we intend for people to only offer the services that they're entitled to use? So this is really about the type of services as opposed to the title themselves. Houston.
I think that the important part to remember as part of this oversight is that the services themselves can continue and they do not change. What we are going to be regulating is the title and the title usage to ensure that there is some currency and there's some meaning behind that. So the individuals and the professionals that engage with clients and do this work, I think it's just critical to know that that work can continue and is not intended that it be changed. But when people start using the financial advisor, financial planner title, at that point, they would need to be part of a credentialing body's membership.
Thanks, Houston. Just for the audience, we have way more questions than we're actually going to have time to answer just based on the time frame. So I'm doing my best to systematically go through the questions as they came in, but I'm just flagging that we may not get to the ones that were recent, but I'm trying my best to try and combine where appropriate. So there's a question coming in: how many credentialing bodies and how many title users under FP and FA does FSRA expect to operate under the new framework? So can you give us a sense of how many credentialing bodies we anticipate having applications for or approving, and how many title users do we think will be under the new regime? Joel, do you want to answer that one?
Sure. It's a difficult one to say because we don't yet know how many credentialing bodies there will be. We don't expect there to be a large number. I would say, certainly not expecting not expecting too far into the double digits. I would say less than double digits in terms of number of credentialing bodies, at least when the framework gets started. In terms of the number of individual financial planners and financial advisors that are out there in the marketplace, Financial planner is one that we have some numbers on based on who holds different credentials right now, like the CFP and the PFP, et cetera. Certainly that's information we can get for you. Financial advisors is a little more difficult because not everybody who uses the financial advisor title falls under the same domain. Some are overseen by different bodies. So until we get it up and running, it'll be hard to know the overall number. I think Houston was looking to chime in on this as well. Oh, sorry, he wasn't.
Perfect. Thanks, Joel. So I'm going to combine a few questions here around the multiplicity of credentialing bodies and potential title users. So will FAs or FPs that hold qualifying credentials from more than one credentialing body need to make an election of one credentialing body as their primary? And in addition, and it's a follow-on, can a person who is qualified to use both titles use both, or will the person need to choose between one of the two? So it's a sort of a two-part question. Houston, do you want to answer that one?
Currently, it's not contemplated that you'd have to sort of choose. You're going to have individuals that, of course, are. They could receive designations from multiple bodies. If more than one of those bodies applies to be a credentialing body, then there will be more than one level of membership that allows that individual to use that title.
And there's maybe you just want to add to the question around, can I use, if I have ability to use both titles, FP and FA, do I need to choose between the two as opposed to within credentialing bodies themselves?
We always appreciate, of course, people wanting to add to their knowledge base. They will have the option and they'll be able to determine which they use. We know that sometimes those different sets of professionals bring different skills to the table, but it'll be up to them.
Great, thank you. This question on fees. So many professional bodies only have a limited number of members that could actually do financial planning or want to use the title. Are the fees restricted only to those members that provide the financial planning service, or will they be charged to all members? Let me just add to that to help clarify the question. It's really about the title users themselves. Are we only going to charge based on the number of people who use the title from a credentialing body or the entire membership base? Joel.
So I think that's one of the details we've been actively talking to prospective credentialing bodies about. It's a big one on a lot of people's minds. So if you have a body that regulates 20,000 individuals, but only 10,000 of those individuals are actively using a financial advisor title, let's say, are you paying your fees based on those 10,000 title users, or are you paying it based on your 20,000 overall members? I would say that's still an active conversation. I don't think we've landed on what the final solution is there, because I think it is difficult to determine who the active title users are among an organization, unless the organization asks for an attestation from all of its members, which is one option, and then we can go by title users as opposed to all of the credential holders. I think, Mark, you had something to add to this.
Yeah, Joel, I mean, it's difficult for us to try and police that if, and I can't remember your exact numbers, but they have 20,000 members or licensees or designates, but only 10,000 use it. We'd be completely open, though, to them creating a subcategory so that the 10,000 are identified in a certain way, and that they'd only seek approval to have that specific, sub designation, if you will, as identified as the FAFP. It would mean the others could not use it. So, we're looking to credentialing bodies to also think about how this will benefit their membership. Our starting assumption is that it will benefit all their designation or license holders equally if they apply to use an FA or FP, or for approval to use FA or FP with those. But it's up to them if they'd like to try and somehow subdivide that in a way that is actually identifiable and manageable. So I, look to them to come up with that solution.
Thanks, Mark. I am conscious of the time. I'm going to get through a couple of more if we can. So why was a best interest standard left out of the framework, or more aptly, why is FSRA not proposing a fiduciary standard for financial planner and financial advisors? Houston, do you want to field this one?
There are certainly lots of opinions in terms of what is the best way to protect investors. We think that that particular issue is best left to those that regulate pure conduct. So there are bodies, including the CSA and others, that have weighed in on that, and that's a decision that those organizations will be making. From our perspective, we think it is of paramount importance to have those proficiency standards, appropriate governance, and appropriate enforcement and oversight, and we're going to be focusing on those elements of the title protection framework to protect investors.
Thanks, Houston. I'm going to try and combine a few questions in the interest of time. So what will the complaints process look like? And in particular, how will you identify individuals that are not eligible to use the FA or FP title? Joel.
Well, I can speak to part of that, certainly. I know that in terms of how we identify those that are misusing the titles or are using them without an approved credential, that will be largely complaints based. If people bring to us knowledge of somebody using a financial planner or a financial advisor title and they don't believe they have an appropriate credential to do so, that is something that they can bring to FSRA, and FSRA can look into taking action against that individual, as I mentioned earlier, in the form of a compliance order. In terms of the actual complaints framework and how they're going to be handled within FSRA, I would probably defer to Houston to lay that out a bit.
So currently we receive complaints, for example, if someone says, this individual's not a mortgage broker. Why did they're holding themselves out and they're providing these services. And we receive complaints that say this individual's not an insurance agent. And we action those by issuing essentially a notice where appropriate to say this individual's not licensed. We see something similar taking place in the title usage framework. So if someone identifies that there is an individual who is not entitled to use the financial advisor, financial planner title, if we transplant ourselves into a regime where this is meaningful and it speaks to the level of proficiency and oversight, then people will recognize that it's got a meaning and it conveys that additional level of protection. Then what we will do is issue a notice after, of course, conducting our own review that identifies that this is a problem, and hopefully before that they will agree to withdraw and not hold themselves out and use that title.
Thanks, Houston. Let's see if we can get through one more. I'll throw this one to Joel. Joel, why not adopt the Quebec model, which provides a more robust consumer protection framework?
It's a great question, and we've certainly talked to our friends in Quebec at the Autorité des Marchés Financiers about this, as well as others. I think Quebec's model is very different. It was brought in about 20 years ago. Essentially, it has one credentialing body, that is the IQPF, that gives out the ability for people to use the planificateur financier, the financial planner credential, and it actually prohibits by regulation, a whole list of other titles. So you can't call yourself a list of about a dozen or so different titles. It is really essentially illegal for you to call yourself anything but that one title. That is not the direction the government opted to go with the legislation that we have in place here in Ontario. It was specific to the financial advisor and financial planner titles, and it was not. There was no regulation created saying you cannot use the following titles. It just said if you want to use the financial planner or financial advisor titles, you will have to get an approved credential from an approved credentialing body, and it did not, unlike in Quebec, designate one specific credentialing body for that function. So this really is designed as a multi-credentialing body, and is again not nearly as prescriptive in terms of with respect to the title usage. That's just a policy choice the government made.
Thanks, Joel. So we are at time, and I just wanted to flag again, we received more questions than we obviously had time to answer. And so I'm just reminding everyone that we will address all other submitted questions and be posting them in a Q&A format on the FSRA website. And I want to thank everyone for joining us today. Any additional questions that you didn't get a chance to ask today through the chat box, please email them to events@fsrao.ca and we will address them. So that would have been the address that sent out the registration. And I also wanted to flag that we are going to be sending out a survey, post-event survey, and we would appreciate your feedback on the sort of format, the background, the content. Any feedback is helpful for us as we look to improve this type of session for going forward. So thank you everyone for being here today. And again, there were more questions than we had time to answer, but we do commit to getting back to folks through our website on the Q&As that were provided today. And we encourage you through the consultation period to please consider providing FSRA with your submission. If you would like more information, on the screen you see two names, Andrea and Kirabel. Please email either one of them and they will be pleased to follow up with you both directly from answering any questions you may have, or we will follow up to try and set up a meeting to talk to you directly as well. So with that, I appreciate everyone's time. I wish you all a great afternoon and hope you all have a wonderful lunch. Thank you very much, everyone. Have a great day.